All right, Professor Wallacord, here we go. Chapter 18. I'm going to try to talk in 6 minutes. I know I like to give a lot of information, but I'm going to try to cut it as best as I can. All right, so to start, this chapter is talking about conditions. So, conditions in most contract promises of performance are not expressly conditioned or qualified. Instead, they are known to be absolute promises. So, they must be performed, or the parties promising the acts will be in breach of contract. In some situations, however, performance is conditioned. A condition is a qualification in a contract based on a possible future event. If the condition is not satisfied, the obligations of the parties are discharged. And a lot of this chapter itself, clearly the title, Performance and Discharge, but if you perform, people are going to love your work, love your hard work, and I think that's what it should be based upon is how hard you work, how well you perform through individually and with others, but I'll get more into that. So there are three types of condition that can be precedent. One is precedent, two is subsequent, and three is concurrent. They can also be classified as either express or implied. So a condition that must be fully, fulfilled before a party's performance can be required is called a condition precedent. So, for example, leasing a contract for housing or is an example of the precedent, or really what we do at college for room and board is also known as a condition precedent. When a condition operates to terminate a party's absolute promise to perform, it is called a condition subsequent, so that's the second one. So an example is when a law firm hires somebody and their contract provides that the firm's obligation continues to employ that person, but that person will be discharged if they fail to pass the bar exam on the second attempt. So when each party's performance is conditioned on the other party's performance or tender of performance, concurrent conditions are present. So these contracts only exist when the contract expressly or impliedly calls for parties to perform their respective duties at the same time or simultaneous. So this is essentially when promises are made, they must be kept no matter what. So it's all about promises. We'll get into a little more of like when you sign a contract, it's essentially a promise that everything listed there is how it's going to work, and that's why there are a lot of lawsuits happen is because people don't read the full contract. So a great majority of contract, as mentioned time and time again throughout the chapter, are discharged by performance. Performance can also be accomplished by tender, which is an unconditional offer to perform by a person who is ready and or able to go, or to do so. So the basic requirements for performance to qualify as substantial performance includes the following. 1. The party must have performed in good faith. 2. The performance must not vary greatly from the performance promised in the contract. And 3. The performance must create substantially the same benefits as promised in the contract. So, makes sense. And so moving on to a reasonable person standard. Most other contracts need to be performed only to the satisfaction of a reasonable person unless they are expressly stated otherwise. So really what I got is this chapter is all about performing, time to perform, doing your own due diligence, and what happens when discharged. So there can be discharge by failing, agreement, mutual rescission, novation, accord and satisfaction, and bankruptcies, another one, etc. Could go on and on. So, performance-based knowledge, you have to work hard and earn your keeps. That's what I got. Is our country, even today, especially the younger generation, want to go a different direction and get things handed to them and think that's okay to just not have to work hard, this and that. But really, we're based on working hard. That's the first thing we're taught when we're younger through the old times is like, you work for what you get. And it's sad to see. I know my dad, there's an example of he was working at the time and his friend was working, but not nearly as much, not nearly as hard. And he says to my dad, like, why do you work so hard? And my dad, us coming from Mexican descent, his dad being a picker in the fields, was like, it's all I know. I just want to work hard, earn my living, blah, blah, blah. And his friend goes, well, after taxes, we're making the same, and kind of laughed at him. But luckily, my dad still kept that mindset, and he's still working hard today and doing what he can to provide for the family. But Yeah, it's like crazy how not working hard and not performing, um, and lack of discharge, sometimes you fail to recognize the quality of that hard work. So I think that's a big thing I got from this chapter. So sorry, but a little example. But moving on, I only have a little bit left, about to be 6 minutes. Mutual rescission is when other parties need to continue making agreements that satisfy the legal requirements. Three basic types of situations. One is when one of the parties to a personal contract dies or becomes incapacitated, I butchered that, prior to performance. Two, when the specific subject matter of the contract is destroyed. And three, when a charge in law renders performance illegally. So lastly, performance can be discharged. Sometimes, however, the lapse of time and change in circumstances surrounding the contract make it substantially more burdensome for the parties to perform promised acts. Chapter 18.